I'm Robert George. I have the honor to be the director of the James Madison Program, American Ideals and Institutions, and I'm McCormick Professor of Jurisprudence here at Princeton. And it is my very great pleasure to welcome you today to our 2025 Walter F. Murphy Lecture in American Constitutionalism. The James Madison Program is dedicated to exploring enduring questions of American constitutional law and Western political thought. If you would like to know more about our program and all the things we do, please visit our website at JMP, James Madison Program, jmp.princeton.edu. You can also follow us on Twitter, where our Twitter handle is simply @Madison Program. On the website, if you visit, you can sign up for our newsletter and subscribe to our Madison's Notes podcast. You can also, of course, there at the website, learn more about all of our upcoming events. Well, the Walter Murphy Lecture honors the memory of my esteemed predecessor as McCormick Professor of Jurisprudence, Walter F. Murphy. He was the fifth McCormick Professor in a line that began with Woodrow Wilson, who was followed by W. F. Willoughby, Edward S. Corwin, and Alpheus T. Mason. Professor Murphy was a distinguished scholar of judicial behavior and of constitutional law, and for nearly 3 decades, he taught Princeton's storied undergraduate course in constitutional interpretation. Walter was also a famous novelist, as I'm sure some of you know, having written the blockbuster bestseller, The Vicar of Christ. It was a kind of fantasy. Can you imagine that thing, that someday there would be an American Pope? Who would have thought? Well, our 2025 Murphy Lecture is a scholar of no less distinction, and I know how delighted Walter would be to know that Professor Ekins is the Walter Murphy Lecturer this year. Professor Ekins is a scholar at Oxford University, where he works on questions of constitutional law and practice and in legal and political philosophy, with a special focus on lawmaking, interpretation, and self-government. Professor Ekins leads Policy Exchange's Judicial Power Project. He co-edits the American Journal of Jurisprudence, not bad for a New Zealander living in England, the American Journal of Jurisprudence, and jointly directs the program for the Foundations of Law and Constitutional Government in Oxford University. He had the great distinction of being made King's Counsel Honoris Causa in 2022 in recognition, and I quote, of his major contribution to public debate and parliamentary deliberation about the constitutional role of courts, unquote. Professor Ekins is the author of The Nature of Legislative Intent, published by Oxford University Press, and he's co-author of Legislative Rights, Securing Human Rights Through Legislation, Cambridge University Press. His lecture today is entitled The Inherited Constitution. Please join me in welcoming Professor Richard Ekins.
Excuse me. Well, thank you, Professor George, for that very kind introduction. It's a great honour to have the opportunity to deliver this year's Walter F. Murphy Lecture, and I'm grateful to you, Robbie, and the James Madison Program for making this possible. Well, in this lecture, as my title suggests, I aim to think about the Constitution as a kind of inheritance. Understanding the Constitution in this way may help to address questions that otherwise quite reasonably arise about the legitimacy of constitutional government. And if the Constitution is an inherited Constitution, this may bear on how we interpret and apply it, and about how we should understand our own responsibility for constitution making. If we inherit the Constitution from our forebears, if you've inherited your Constitution from Americans who came before you, then our children stand to inherit from us in turn. And this makes it imperative we take seriously our responsibility to secure their inheritance, rather than to let it slip away or be plundered, and perhaps also to add to it as best we can, to leave them a framework of government that is in good working order. So, thinking about our constitutional arrangements as an inheritance promises to sharpen our understanding of the morality of constitutional government and self-government over time. Let me briefly outline how I intend to proceed. I'll begin by reflecting on the problem of the constitutional authority of the framers and ratifiers of the United States Constitution, the so-called dead hand of the past. I'll then consider some accounts of authority over time, moving quickly through the work of the three great legal philosophers of the last 50 years, Joseph Raz, Ronald Dworkin, and John Finnis. What this will reveal, I hope, is the importance of a principle of continuity and of a continuing political community that accepts this principle. I'll then go on to consider Edmund Burke's argument that the Constitution is an inheritance and the reasons why it's good for a people to understand their past, present, and future in this way. I'll then turn to the questions of what it is that we inherit and who it is that inherits. The first question points us to the complexity of constitutional inheritance and the layers of history that need to be addressed if we are to understand what exactly we have inherited. The second question concerns the way in which a people understands itself over time, the dispositions its members must share to keep faith with the past, and the scope of its membership. And the final part of this lecture will touch on how the courts should interpret and apply an inherited constitution, and about the importance of deliberate constitutional change. Let me begin with the problem of constitutional authority. Writing in the late 1990s, Michael McConnell noted that, quote, "The first question any advocate of constitutionalism must answer is why Americans of today should be bound by the decisions of people some 212 years ago. The framers and ratifiers did not represent us, and in many cases did not even represent people like us, if we happen to be Catholic or Jewish or female or black or poor. What is most devastating to any claim of authority on their part is that the framers and ratifiers are long dead. Why should their decisions prevent the people of today from governing ourselves as we see fit?" End quote. This, he says, is the dead hand of the past problem. The framers and ratifiers were too narrow a set then to enjoy legitimacy now, and in any case they're dead and gone. Hence the same problem would afflict any attempt at constitution making, even if the whole people in the past had truly been involved. Now, while usually deployed against originalism, McConnell notes that the dead hand of the past would be, if it were accepted, a problem for any form of constitutionalism. Well, some key figures at the American founding made a similar argument. Noah Webster argued that the attempt to make perpetual constitutions is the assumption of a right to control the opinions of future generations and to legislate for those over whom we have as little authority as we have over a nation in Asia. Thomas Jefferson argued that by the law of nature, one generation is to another as one independent nation to another. No society can make a perpetual constitution or even a perpetual law. The earth belongs always to the living generation. And rejecting Burke's analysis, Thomas Paine said that past generations have neither the right nor the power to control their posterity. As government is for the living and not for the dead, it is the living only that has any right in it. Well, I agree that attempting to disable future generations from constitutional change would be an act of hubris. But I disagree that one generation is to another as one independent nation to another. I think the framers and ratifiers in the late 18th century exercised legitimate authority. I pass no comment on the legitimacy of the American Revolution itself, which is a separate question. But having broken forcefully from Britain, the 13 colonies certainly found themselves with a common good that needed to be protected, with an urgent task of government before them. And for good reason, they thought this was not a task that could be pursued as 13 neighbouring independent states, hence the Articles of Confederation. And when that proved an inadequate frame of government, it warranted revision. And the framers may have exceeded their brief, but their handiwork was adopted by the states by way of ratifying conventions, which represented each state and committed them to the new constitution. In this way, the people of the United States acted, by way of their representative institutions, to form a new, or rather a more perfect, union, adopting a new framework for government. It's true that the framers were a narrow set of men, although obviously a very talented group, and the ratifiers were also drawn from a fairly narrow subset of members of the political community, namely propertied men, with women, children, and poorer men excluded. The Indian tribes were understood to be separate peoples, and enslaved persons were clearly denied any opportunity to participate in the constitution-making moment, with the constitution not disturbing their enslavement and thus their exclusion from membership of the people. Nonetheless, the framers and ratifiers were in a practical position to exercise that high power of government which is constitution making. In exercising that power, and in being accepted to have exercised it by the persons and states over whom they claimed authority, they created a new form of political community, setting out a framework by which that political community was to be ruled, or rather to rule itself. This was a responsible provision for the common good of the people of the United States. Now, I don't mean that the detail of the Constitution was all well made. Disabling Congress for 20 years from abolishing the foreign slave trade was unjust, although the counterpoint is that this was a compromise necessary to induce the slave states to submit to the authority of a Congress that 20 years later would be free to act. The ratification of the Bill of Rights, soon after the adoption of the Constitution, may also have been a mistake for reasons that I will consider later. Still, the framers and ratifiers exercised their authority to commit the people of the United States to a new framework of government, which did establish justice, ensure domestic tranquility, provide for common defence, promote the general welfare, and secure the blessings of liberty. It does not seem to me to have been presumptuous of the framers and ratifiers to have made this provision. The preamble says, we the people aim to secure the blessings of liberty to ourselves and our posterity. But in one sense, that must be true for all the objectives of the Constitution. The people of the United States made provision for themselves and Americans yet to come, which was a responsible course of action in the circumstances in which they found themselves. It's true and important that by the mid-19th century, the Constitution proved unable to contain the political disagreements between North and South, with the seceding southern states refusing to continue to share this framework for government. The Constitution needed to be remade after the Civil War by the victorious party, at which point the people of the United States, having largely disabled the southern states, adopted a new settlement. It was new, a resettlement, because the framers and ratifiers in the late 18th century, given the political circumstances in which they acted, had not been in a position to make this settlement themselves. But the framework of government that they did adopt made this resettlement possible 3/4 of a century later. However, what is one to make of the continuing authority of the framers and ratifiers hundreds of years after they acted, when the conditions they envisaged may have long since passed away? Or to put the point differently, do the framers and ratifiers still have legitimate authority? Does the Constitution that they made continue to bind Americans now in conscience? Well, the late Joseph Raz was the leading scholar of authority of our time, and he developed, as many of you will know, a powerful understanding of authority as the provision of a service to the subjects of authority, helping them better conform to good reasons. Well, in his reflections on the authority of constitution makers, Raz questioned how long this authority could endure. In the immediate aftermath of an act of constitution making, or any act of legislating, the authority of the authors would hold, for one would do better by complying with their choice about what should be done than by following one's own judgment. But this rationale for authority broke down, Raz argued, the further one moved away from the moment of constitution making, or legislating, which is when the constitution maker acted, when it considered relevant reasons, and made its provision for what should be done. Now, there's an obvious good sense to this analysis. The lawmaker's foresight is limited. The further we move away from the conditions in relation to which a rule was made, the more reason there may be to think that the rule no longer works. And the passage of time means that conditions will change. What this means, Raz says, is that the authority of the authors of the Constitution decays over time. At some point, which cannot be specified with exactitude, they no longer have authority. But this does not mean, for him, that one simply walks away from the law they made. Raz argues that continuity with the past is important, if only to protect expectations. But importantly, continuity is not the only relevant consideration. He conceives of interpretation in general, so not only in the constitutional context. He conceives of it as involving a play of competing forces between conservation and innovation. Thus, over time, the law that was made may change as judges innovate more and conserve less. Now, despite its elements of good sense, this is not a stable and satisfactory understanding of constitution making, or indeed of lawmaking in general. It introduces into legal reasoning a ground to unsettle existing arrangements in the course of purporting to elucidate them, which may wreck the provision that the constitution maker made. Now, it may seem I'm begging the question against Raz, because the whole controversy is about the extent to which constitution makers several centuries ago are able to bind us now. My point is that thinking of authority as decaying over time is undisciplined. It risks constitutional unsettlement and the loss of the goods of stability and concord that a constitution aimed to secure. Now, no one should deny that the passage of time may make a past choice inapposite now. That would be a good reason to revise the choice now by way of a power of amendment. But barring such amendment, it's risky to take the choice, and who is to take it, of treating the constitutive authority as simply fading away at some postulated rate. Postulated by whom? For whether the authority has decayed is a question that should be settled by authority. Raz's understanding of constitution making risks handing over to judges authority to gloss or narrow past constitutional choices, such that the people no longer rule themselves. For Ronald Dworkin, by contrast, it's a mistake to think in terms of authority at all. This doesn't mean one shrugs off the past and does as one now pleases. The life of the law, on his view, is a moral argument about how best to understand and extend the past, which includes the actions of the framers and ratifiers several centuries ago. But those actions should not be understood to have been an exercise of authority that settles now what must be done. They were momentous political events which need to form part of a continuous story about the commitments of the American people. Thus, for Dworkin, the actions of the framers and ratifiers must be explained, but the constitutional law that arises from their actions is not settled by them. It's instead to be found in an unfolding narrative about the way in which their actions are received and taken up over time. The decisions made by the framers and ratifiers, including the constitutional text they wrote, may over time recede ever more into the background. Well, Dworkin sometimes attributes to the framers and ratifiers an intention to set in motion just such a constitutional practice, adopting open-ended principles of government or affirmations of abstract rights that require judges to elaborate their meaning in novel ways over time. This may have some traction in relation to some constitutional provisions, although I think one should certainly pause before accepting Dworkin's assertions that they were intended to be open-ended. But it's much harder to credit in relation to other or many other constitutional provisions. And the theory as a whole should be rejected precisely because it does not recognise authority. Instead, on this view, the Constitution becomes a kind of source for common law reasoning, in which judges move, case by case, further and further from the source. Now, as you'll have inferred, I'm not persuaded by this understanding of law or legal reasoning. That said, there is something attractive, in principle at least, about Dworkin's official image of the law as the commitments of the community personified. He invites us to imagine the political community as a person and to ask how the various laws and practices of this person might make rational sense together. This is the virtue of integrity, which plays such a pivotal role in his jurisprudence. Now, it is, as I say, an attractive image. My concern about it is that for Dworkin, it is only an image, for he in effect denies the capacity of the people to make commitments or to exercise agency. Indeed, he even denies Congress's capacity to act on behalf of the people in this way. It turns out that only Justice Hercules, Dworkin's avatar for good jurisprudence, is able to speak for the community personified, which makes the Supreme Court the tribune of the people. This is not a theory that can explain constitutional government or self-government. Well, let me turn now to John Finnis's contribution to this discussion. Finnis agrees with much that Joseph Raz has had to say about authority, but he does not adopt Raz's notion that the authority of the authors decays over time. He approaches the problem from a somewhat different direction, informed by his study of the constitutional law and practice throughout the British Commonwealth. In his landmark paper, Revolutions and the Continuity of Law, he notes that in many times and places, new rulers come to power in violation of the old constitution, yet without their ascendancy disrupting many other rules that were made by those who were once in power. Having established themselves in office, the new rulers may make new laws, including repealing the old, but unless and until they do so, the old rules remain in force, despite the fact that the institution that made them no longer has authority. And one sees something similar after peaceful independence. Parts of the law of New Zealand or India remain as they are because of British colonial legislation, despite the British Parliament no longer having authority in either state. Laws made for New Zealand or India by the British Parliament remain in force unless and until repealed or amended by legislatures in these independent states. Well, Finnis derives from his study of revolutionary change and peaceful devolution what he terms the general principle of continuity. Quote, "A law once validly brought into being, in accordance with criteria of validity then in force, remains valid until either it expires according to its own terms or terms implied at its creation, or it is repealed in accordance with conditions of repeal in force at the time of its repeal." End quote. That principle is a central entailment of the very idea of positive law. For, to quote him again, the general principle presupposes, expresses and realises, or secures, the most general and basic function of the law, namely to relate the past to the present by providing a present guide to actions which take place and have effect in the future, when this present will be in the past. End quote. The question then is not whether the framers and ratifiers still have authority over us today, but rather whether, and if so to what extent, the constitutional law that they made in the late 18th century, in exercise of their constitution-making authority then, has been changed since. Now, this analysis may all seem a little bit beside the point. Isn't the problem that while the people, or at least some of the people, may have consented to the Constitution in the late 18th century, almost no one alive today has consented to it now? And if the rationale for legitimate government is the consent of the governed, how is the Constitution a legitimate framework for government? Well, the short answer, I think, is that the consent of the governed is not the foundation of legitimate government. Whether the people consent to a form of government does not establish whether it has authority. Withdrawal of consent does not itself remove authority to rule, although it may change the relevant social facts in a way that undercuts the capacity to rule and thus changes who it is that should rule. The rationale for authority is the common good, which gives each of us good reason to accept the authority of whoever is able in practice to direct common action and public life. The location of authority should be settled by exercise of authority. There are very good reasons to settle the location of authority in a way that shares it amongst many officers, including the ordinary mass of the people. Aquinas made that point. It makes very good sense for whoever is in authority to seek the support of the people. Whoever exercises authority is much better placed to secure the common good of the community if the people accept that his or her authority is legitimate, if they adopt the choice of the ruler about what should be done as if it were his or her own, again to follow Aquinas. So my point is not that popular support for government is unimportant, still less that constitutional design should be indifferent to democratic principle. On the contrary, in making provision for the location of authority, constitution makers should keep firmly in mind the value of enabling self-government. A good form of government is one that makes it possible for institutions acting on behalf of the whole people to rule effectively and well, in a way that shares authority with the people and thus realises self-government over time. My point is that the legitimacy of the Constitution does not turn on popular consent now. The Constitution was made by those with authority at the time, and it settles the location of authority now. Insofar as this establishes a form of government that is able to secure the common good, it is legitimate and deserves support, even though it was not chosen by anyone alive today. The Constitution does share authority with the people now, although one may question whether it does so adequately. One may question further whether the Constitution makes adequate provision for the people to change the Constitution itself from time to time. The Constitution might be bad law precisely because it is or has become too difficult to change. But being bad law is not the same as being unjust law. Insofar as there is a dead hand of the past problem, it does not lie in the fact that the law under which we live was made by people long dead and buried. The problem arises if, or when, or to the extent that people living now are in practice disabled from changing the law and thus cannot take responsibility for their common good or for posterity, including by making constitutional change. Well, the argument I've developed is similar in form to Burke's repudiation of the asserted right to form a government for ourselves, in his Reflections on the Revolution in France, published in 1790. Now, the immediate context of his remarks was an argument about how to understand the glorious revolution, so-called, of 1688-89. The revolution was made, Burke says, to preserve our ancient, indisputable laws and liberties, and that ancient constitution of government, which is our only security for law and liberty. Now, it's at this point that he introduces the idea of inheritance, an idea to which he returns repeatedly. Far from asserting an inherent right to form a new government, Burke says that, quote, "We wished at the period of the Revolution, and do now wish, to derive all we possess as an inheritance from our forefathers. Upon that body and stock of inheritance, we have taken care not to inoculate any scion, that is, not to engraft any new shoot, alien to the nature of the original plant. All the reformations we have hitherto made have proceeded upon the principle of reference to antiquity." End quote. And he then sets out to prove the point by examining these various reformations of the Constitution. The oldest was Magna Carta, and he acknowledges that the lawyers may have overstated its continuity with ancient law. But their reliance on history, Burke says, confirmed that the stationary policy of this kingdom is to consider their most sacred rights and franchises as an inheritance. He then goes on to quote from the Petition of Right in 1628, where Parliament says to the king, "Your subjects have inherited this freedom." Thus, says Burke, parliamentarians were, quote, "claiming their franchises not on abstract principles, as the rights of men, but as the rights of Englishmen, and as a patrimony derived from their forefathers." End quote. The same concern to vindicate religion, laws, and liberties as long possessed is apparent in the Declaration of Right, with which William and Mary cemented the Glorious Revolution. Burke says that, quote, "You will observe that from Magna Carta to the Declaration of Right, it has been the uniform policy of our Constitution to claim and assert our liberties as an entailed inheritance derived to us from our forefathers, and to be transmitted to our posterity as an estate especially belonging to the people of this kingdom, without any reference whatever to any other more general or prior right. By this means our Constitution preserves an unity in so great a diversity of its parts. We have an inheritable crown, an inheritable peerage, and a House of Commons and a people inheriting privileges, franchises, and liberties from a long line of ancestors." End quote. So, the English repeatedly claim and assert their liberties as an estate belonging to the people. Now, Burke has not yet developed much of an argument for why this is the stationary policy of the English. He comes close in saying that by this means our Constitution preserves an unity. The context for his reflection is, after all, an unfolding calamity across the English Channel, in which the French Constitution is being cast aside under a claimed right to form a new government. Well, what is there to be said for this constitutional policy of the English? Burke claims that a spirit of innovation is likely to arise from selfishness, and that those who never look back to their ancestors are unlikely to look forward to posterity and its, or rather their, interests, their well-being. More specifically, he says that, quote, "The people of England well know that the idea of inheritance furnishes a sure principle of conservation and a sure principle of transmission, without at all excluding a principle of improvement." And there are three elements here. The idea of inheritance provides a ground on which to conserve what has gone before, what has been enjoyed by those who came before us. It provides a ground on which to pass on what we have enjoyed to those who come after us, for whom we are responsible to this extent. And crucially, the idea of inheritance does not exclude improvement of what we have received, such that we pass on more and better to those who come after us. That is, what we inherit is secure, but we may add to it and improve it before we pass it on. This constitutional policy conforms to the pattern of nature, Burke says, the pattern of nature whereby various goods, including from Providence, are handed down to us and from us. A political system framed on this principle, Burke argues, will be able to endure over time, grounding itself in the past while making adaptations for the future. When we undertake to live in this way, as he says the English people have undertaken, then in this choice of inheritance, we have given to our frame of polity the image of a relation in blood, binding up the constitution of our country with our dearest domestic ties. adopting our fundamental laws into the bosom of our family affections, keeping inseparable and cherishing with the warmth of all their combined and mutually reflected charities our state, our hearths, our sepulchres, and our altars. The inherited constitution, then, is not an imposition, still less a dissolvable compact for mutual advantage, but a commitment in the nature of a family commitment in which the people are joined together by love. For many people, including Americans today and the English in Burke's time, the constitution that we have has largely been made by people who came before us. They exercised their authority to make provision for our common good, and the appropriate response to their efforts on our behalf is gratitude. We have the enormous advantage of not having to attempt to secure government from first principles, in a context where authority is not secure, and thus life and liberty are in constant peril. Insofar as the location of authority has been settled by authority, we have reason to be grateful. Insofar as authority has been exercised to make thoughtful provision for good government, and at the same time for self-government, we have even more reason to be grateful. And John Finnis made a similar point, arguing that, quote, a reasonable patriotism includes an understanding that a broadly worthy constitution, in its place in the sequence of constitutional forms of our constitution, is one of the fine things, our patrimony and social capital, to which it is good to be attached, in large measure because one is grateful that these things were made to be and are there for us all in our infancy, maturity, and we hope in any later dependency. Well, let me try to bring some of these points together. It is good for a people to understand its constitution to be an inheritance. This will help to secure political unity, in which we recognise one another as compatriots, sharing a constitution and a common good, and thus open to sharing power over time. Political unity is the foundation for effective joint government, joint action over time. And if or when it fractures, we risk disaster. Understanding the constitution to be our inheritance will help attach us to one another and to our institutions, which we will understand not as temporarily ascendant foreign forces, but as established domestic offices, the present occupants of which, like those who came before them, are capable, at least in principle, of serving all of us jointly. It will help us, and those who exercise authority over us and act in our name, to adopt a balanced attitude to past and present, recognising and esteeming the achievements of the past without neglecting our responsibility for the future, for our present will soon be our children's past. This disposition is a partial counterweight to the remorseless presentism of our age, in which there's little or no concern for history and little or no provision made for posterity. Relatedly, understanding the Constitution to be an inheritance, such that we jealously guard our long-established liberties, franchises and privileges, will help us keep firmly in mind the fragility of goods and the importance of joint effort and sacrifice to maintain them. This, in turn, may, as Burke suggests, help to temper the exercise of freedom, which might otherwise descend into license, by keeping in mind historical experience and joining us to measure ourselves in part against those who came before us and to set an example to those who come after us. Now, I should note at this point that, of course, an inheritance may be a mixed blessing. It may not be a blessing at all, so much as a curse, and it may often be a predicament. Much turns on whether one inherits a broadly worthy constitution, as Finnis put it, and as Burke may assume. Although even if the constitution is impaired, it may still be much better to work within it than to cast it aside and attempt a reformulation from first principles. The idea of a constitution as an inheritance may suggest that the duty of the citizen or official now is to preserve what's been received, transmitting it to posterity without variation. But this would be a failure of responsibility, including on Burke's own terms. He was at pains to note that, quote, a state without the means of some change is without the means of its conservation. And he defended the Glorious Revolution as an extra constitutional change that was justified in order to preserve the fundamentals of the ancient constitution. He himself was prepared to support quite far-reaching constitutional changes when he judged this to be necessary, including union with Ireland and reform of imperial rule in India. It would be wrong to take the idea of an inherited constitution to imply that the best is behind us, that the duty of those now living is simply to keep faith with or to return to the past. A constitutional inheritance should be a gift, not a snare, and the constitution we inherit needs to be maintained as a framework for government for an indefinite and uncertain future. We are obliged to consider whether the arrangements we have inherited are in need of repair or even replacement, and a good constitutional inheritance will make provision for us to deliberate about this very question and to act when need be. In such deliberation, we should of course take seriously the historical record, making use of the experience of those who came before us and being careful not to discount the benefits of the status quo to which people are likely to be attached. The balanced perspective that is required, I think, is aptly captured by William Blackstone, speaking of those who had the honour to represent their country in Parliament. This is what he said: "They are the guardians of the English Constitution, the makers, repealers and interpreters of the English laws, delegated to watch, to check and to avert every dangerous innovation, to propose, to adopt and to cherish any solid and well-weighed improvement, bound by every tie of nature, of honour and of religion, to transmit that constitution and those laws to their posterity, amended if possible, at least without any derogation. So their duty to guard the constitution they inherit, to resist rash change, to support thoughtful change, and to bequeath an improved constitution to those who came after them." Now, Blackstone takes for granted, as I think did Burke, that Parliament has the authority to make such changes to the law, even constitutional law, such changes as are necessary to improve it. Let me turn now to how a people inherits a constitution. The continuity of legal order turns on the unity over time of the political community itself. And that unity presupposes the willingness of members to act jointly, to conceive of each other as members of a continuing group with and for which they should sacrifice and share. This self-conception involves and reproduces generalised trust that overcomes competing calls on one's loyalty, surrender to which imperils the project of stable, ordered public life. And it's worth asking about the preconditions for this generalised trust. No doubt a shared language, religion, customs and habits often form part of the explanation. So too does a shared past. The members of a people should recognise that they share a common good and that they have a history of successfully seeking it together, even a history that may be mixed with much suffering and misadventure. Insofar as a people shares a history of government, a continued willingness to share government in the future is a less risky proposition than would otherwise be the case. The people share an inheritance because a constitution was made for them by their forebears, a constitution under which they now labour in exercising self-government. The people should be jointly grateful for this provision and should be able both to see themselves and those who came before them and to hope that those who come after them will do the same. Hence, the people owe gratitude to the past and responsibility to the future, which spurs action in the present. And this arrangement of past, present and future is key to what it means to be a people. Shared historical experience and a firm commitment to future joint action are vital to the self-understanding of any mature and well-formed people. It's hard to see how else one could truly inherit or bestow a constitution. For inheriting a constitution requires more than simply coming later in time, but requires rather that the people see the constitution as something made for them by their forebears, as their entailed inheritance. Who is it that forms the people? Who inherits the constitution? Well, modern states have complex laws of citizenship, as well as intermediate categories of non-citizen who are entitled to reside and maybe even to exercise political rights. Citizens form the people, of course, but some non-citizens may belong in a secondary sense. Natural-born citizens will share many ties of language, custom, religion, common culture. They may be more or less familiar with their own history. Insofar as citizens do not understand themselves to be in historical continuity with those who came before them, they are likely to fail to recognise their constitution as an inheritance. A federated people may face particular challenges, with citizens at once members of the nation and of a particular state, political identities that may, under certain conditions, come apart. Quite apart from federalism, natural-born citizens may have different perspectives on the historical experience, with, for example, descendants of Native Americans and of enslaved African Americans forming part of the people of the United States now, and yet tracing their descent in part from those who were not understood to form part of the people at key points in the past. Now, for these citizens, their forebears may include both members of dependent foreign peoples or enslaved persons, and those who formed the people of the United States in the late 18th century, some of whom framed and ratified the Constitution. Naturalised citizens may lack many of the shared understandings that connect existing citizens. In choosing to become citizens and being accepted as such, they may well understand themselves to be joining a people with a history, which then becomes theirs by adoption. But this is far from assured, especially if citizenship is acquired mainly for economic reasons, if they fail to integrate, or if the culture they join is one that's relatively indifferent to its own history. Illegal migrants, asylum seekers, or refugees will not form part of the people in any strict sense. The Constitution is not their inheritance. But their de facto presence, especially on a large scale, may weaken the shared bonds of the people and thus its capacity to inherit a constitution. Part of the reason why migration, legal and illegal, has become the central political question in most Western states is that it goes to the heart of who forms the people, and whether those who form it now or formed in recent memory are still capable of deciding who they shall be. A people that's constituted in part by recent arrivals who have not been invited or integrated, who do not share a history, is poorly placed to inherit a constitution or to maintain political unity. Now, with Burke, I've largely been assuming that we, the people, inherit a constitution from our forebears, and this is, I think, the central case of constitutional inheritance. And one could, of course, inherit it, at least in part, from one's kith and kin, from whom one is now sundered, which seems to me the relationship between the early United States and Britain. Relatedly, the inheritance could be received from a colonial power, as with the British legacy of constitution making, and in some instances of prior people establishing, around the world, or even from a victorious conqueror, as with the Japanese constitution, imposed by the United States after the Second World War. So, in a secondary sense at least, one can inherit a constitution from many sources. Over time, as successive generations make the inheritance their own and pass it on in their turn, making such changes as seem fit to them, they will domesticate it, such that it becomes ever more an inheritance from one's forebears. But for a time at least, the source may be relevant to its reception, and thus to the extent to which the inheritance is secure and capable of grounding political unity and attachment. Well, what is it that we inherit? I've been discussing the idea of constitutional inheritance in part in conversation with Burke, but of course Burke was writing about a polity that had no canonical framework for government, no supreme law that settled how Britain was to be governed, no constitution with a capital C. Now, perhaps you're tempted to think, with Richard Epstein, that the British Constitution is not worth the paper it's not written on. Burke disagreed, and so I think did the American founders. Britain certainly had a constitution at the time of the American Revolution, as did England before it. But it was, of course, not a constitution of the type that your forebears later established. We can usefully distinguish the enacted constitution from the unenacted constitution. The Constitution of the United States, which came into force in 1789, is an enacted constitution. Indeed, one might say it was the enacted constitution par excellence. But it does not exhaust the American Constitution in the wider sense. One cannot understand how America is governed simply by reading the Constitution as amended. That's obvious enough. One needs at minimum to understand and probably to master the Supreme Court's case law about the meaning and application of the Constitution. One also needs to grapple with the President and Congress's understanding of constitutional questions that the Court will not consider because it treats them as political questions. But quite apart from the Constitution itself, with a capital C, many laws enacted by Congress concern the framework of government, and thus are part of the Constitution in the broader sense that I'm using here. Consider amongst many examples the Judiciary Act, the War Powers Act, the Administrative Procedure Act, the Civil Rights Act, the Voting Rights Act, the Indian Citizenship Act. Now, these enactments are not strictly entrenched. They're not entrenched against future change. They don't form part of the supreme law of the land. However, they form part of the Constitution in this wider sense, which successive generations of Americans inherit. So the Constitution you enjoy today was made not only by the framers and ratifiers, and by those who secured constitutional amendments, but also by Congress in enacting ordinary legislation. Well, like other countries, the United States has an unwritten constitution as well as a written constitution. The framework of government in its widest sense includes political practices and what are elsewhere termed constitutional conventions, which are non-legal rules. Consider the duty of electors in the Electoral College to vote for the candidate they pledge to vote for, a duty that is not legal but is of high constitutional importance. Or the duty of a president not to seek election for a third term, a duty now entrenched in constitutional law, but once a customary rule of political practice. These rules, too, form part of the inherited Constitution. They do not form part of the supreme law itself, but they frame how the United States is governed. In addition, the Constitution in this wider sense is shaped by changes in the practice of politics and government, which may not involve any particular rules, but are very important. For example, the rise of competitive party politics clearly transforms the dynamics within Congress and between Congress, the President, and the electorate in ways that depart from the Madisonian model. The changes do not breach constitutional law, but they transform the framework. The same might be true for the rise of the so-called administrative state or imperial presidency, which have been achieved by exercises of congressional power and changes in executive organisation. Now, maybe this involved unconstitutional delegation of authority. Still, these seem to be fairly secure and very important features of the American Constitution as it has developed since the founding. Over the centuries, Congress and the President have exercised their powers jointly to transform the structure of government, adding significantly to the Constitution that Americans now inherit. One might say something similar about the rise of the Supreme Court. The role of the court's been controversial for centuries, of course, and as the court's membership changes, its doctrine is sometimes tempered or even reversed. But the Constitution that Americans now inherit is one in which the court seems utterly central, partly by way of rights adjudication, but also by claiming authority to interpret and to supervise the whole. Now, the difference between this and the rise of the administrative state is that the ascendancy of the court has been a change brought about largely by the court itself, rather than by political institutions accountable to the people. This is a complex and multi-layered inheritance, which gets more complex over time. Much room for disagreement about how the different layers relate to one another. Part of the inheritance is an insistence on the value of law. Another part is recognition that law is not the only important thing. The habits and morals of a people may matter just as much. What it is that Americans inherit is thus often a matter for argument. So too is the question of how to understand that inheritance, and thus how to evaluate proposed innovations. What I have been saying is that the Constitution that Americans now inherit was made by the people of the United States and their representatives in the past, not only in 1789, but across the years that follow, and that Americans now form part of the historically continuous people that made this Constitution and passed it down to them, and that insofar as the Constitution, enacted and unenacted, is a broadly worthy framework for government, it's one of many good things passed down to you from your forebears. It makes sense then to be grateful for it and to accept that it remains authoritative until changed. But none of this has denied that it remains subject to evaluation, and it will need to be reformed or improved from time to time, not in the light of some abstract plan, but rather to address real problems. The extent to which the Constitution is open to change is very important, for there's a risk that an inheritance will otherwise become a trap, that it will disable rather than enable self-government. The whole premise of Burke's defence of inheritance is that change is possible. Same holds for my praise for the inherited Constitution. It's imperative it be subject to deliberate change. Well, how should one interpret and apply an inherited Constitution? The framers and ratifiers had authority in 1789 to make constitutional law for the United States. The same is true for Congress and the states that amended the Constitution thereafter. The inherited Constitution, the continuity of law and political community, requires fidelity to their lawmaking choices unless and until they are changed by a valid act of constitution making. Interpreting the Constitution as, in the modern jargon, a living constitution denies the authority of the framers and ratifiers and strips from the people part of their constitutional birthright. Remaking the Constitution in the course of adjudication is a breaking of faith with those who came before, frustrating their transmission of the Constitution that they inherited and made. When judges apply the Constitution, especially in striking down legislation on the ground that it's unconstitutional, they purport to uphold and apply the people's own past commitments. And the rationale collapses if what is upheld and applied is not something included in the people's own past commitments, freely made by valid exercise of constitution-making authority, but rather the court's own choice of how the United States should best be governed. As John Finnis put it, when the judiciary without legally sound ground invalidates just legislation, there's a special humiliation or a special insult added to the injury done, which is the inauthenticity of the appearances which the court in these cases keeps up, the appearance of doing what courts characteristically do when doing justice according to law. Now, one might say that Americans have inherited a de facto arrangement in which judges are supreme, and in which a change in judicial doctrine is the principal means of constitutional change. That may well be true, but a judicial practice of more or less openly remaking the Constitution from case to case is in obvious tension with the supremacy of the Constitution itself, as well as with Congress's power and the state's power to make law within clear constitutional limits. It's a practice that fails to take fully seriously the people's constitutional inheritance. Now again, none of this is to deny the need for ongoing capacity to change the law. But change, I have been suggesting, should be led by political institutions, and space should be made for political action. It does seem to me to be a serious problem that the Constitution is too hard now to change. This problem may be deployed sometimes to rationalise judicial adventurism on the premise that unless the court acts to affirm it, some new right will fail to be adequately protected. But the pressing need for constitutional change is not that new rights need to be added to the constitutional panoply of rights, but rather that the political authorities may lack the power they need to secure the common good. The 1789 Constitution was a new beginning, but it built on earlier foundations. Insofar as the framers and ratifiers shared Burke's constitutional policy, then in making a new constitution, they were trying to vindicate long-standing ancient rights. They were making provision for how the new United States should be governed, drawing on the British inheritance to put the new political community on a sound footing. Now, if that's the right way to understand their constitutional policy, one should firmly reject Dworkin's argument, echoed by so-called living originalists, that the framers and ratifiers intended to affirm open-ended principles which would then be for judges to elaborate over time. In acting in that way, the framers and ratifiers would not have been taking seriously their responsibility to make provision for constitutional government, to vindicate established rights, and to leave to their successors the freedom to decide how or whether to modify this inheritance. Now, I said before that the adoption of the Bill of Rights seemed to me to have been a mistake. Why? Its adoption, I think, has provided a foothold for far-reaching judicial lawmaking, going well beyond the clear commitments of the people in a way that's hard to square with self-government. However, it's arguable, it's recently been argued, that in adopting the Bill of Rights, what was intended was the declaration of natural or customary rights, which legislatures would then protect. Now, if that argument has force, then scepticism about constitutional rights adjudication is doubly warranted, for its foundation in a past act of the people would fall away. In any case, there's much to be said for judicial adoption of a Thayerian standard of constitutional review, finding a breach of the Constitution only in very clear cases. This standard would keep faith with the enacted Constitution, but would leave more space for political institutions to deliberate freely and to act as they see best. The role of the courts in upholding the Constitution was not spelled out clearly in the founding. A robust judicial role has since developed, sometimes paired with measures to temper it. The judicial role has clearly been a mixed one over time, sometimes giving rise to various disasters. That should caution the approach taken by judges now to adjudication. A so-called traditionalist approach to constitutional interpretation, in which judges focus on long-standing political practices rather than on abstract principle or judicial precedent, might seem closer in spirit to the inherited Constitution. The object of sound constitutional interpretation, I think, should be the Constitution making choices made by those with authority to act on the people's behalf. But in exercising authority to adjudicate constitutional disputes, the courts should be slow to interrupt long-standing political practices. They should likewise be slow to reverse well-established judicial precedent, although hard cases will arise when precedent secures departure from the Constitution itself. The Supreme Court's new enthusiasm for history and tradition as a means to specify the limits of constitutional rights seems an unhappy compromise, or at least an unstable development. The Court's ambition seems to be defined in historical materials, a ground for decision, enabling it to differentiate government action that will or will not breach an underdetermined right. But the materials may not support such a distinction, and the standing risk is that the court ends up narrowing prematurely the government's capacity to act for common good. It would be better to recover a sense that specification of underdetermined rights is for legislatures. Well, I've said more than once that an inherited constitution should be open to change. That change may involve formal amendment of the Constitution itself. It may also involve enacting acts of Congress that help frame the exercise of government. And courts, I think, should be slow to interfere with Congress when it acts in that way. From afar, it seems to me that American constitutional practice has resulted in the Supreme Court becoming the main forum for constitutional change, which distorts law and legal reasoning and sets in motion an unhealthy political dynamic whereby other modes of change atrophy. It's worrying, I think, that the most recent proposal for amendment to be adopted, the 26th Amendment, was made as long ago as 1971. The most recent amendment, the 27th, was proposed in 1789. It seems likely then that the amendment procedure itself may require reform. Now, it may be difficult to imagine reviving the amendment procedure as an effective means of change. And there is a complication to be borne in mind when contemplating such a revival. If constitutional amendments were to become more common, it is likely that judges would be invited to invalidate some of them by reference to abstract constitutional principle. That technique has been pioneered, so to speak, by the Supreme Court of India, which appeals to the unwritten, judicially discerned or invented basic structure of the Indian constitution to invalidate otherwise valid amendments. And some other leading courts around the world have followed suit. And scholars have rationalised this practice on the grounds that it prevents the fundamental constituent power of the people being subverted by the constituted power of amendment. It seems to me to be an inversion of the idea of self-government. It's not a vindication of the inherited constitution. It's an attack on the people's freedom to improve what they've received, a freedom that is itself part of the inheritance. This new judicial practice traps the people in a constitution made by others, with the court tacitly reserving to itself authority to decide when or if the constitution shall be changed. This practice is not yet a feature of American jurisprudence, as I understand it, and I hope it never will be. Well, let me conclude by reiterating 8 things I've said this evening. Like other peoples, the American people inherit a constitution from their forebears. This includes the enacted constitution itself, but much more besides. It matters that this is an inheritance. It should be valued and not lightly departed from. Sharing a constitutional inheritance is a reason for gratitude and for attachment to our institutions and to one another, a reason to temper our exercise of freedom by reference to the wisdom of the past. But each generation should be able to change the constitution if need be. Some main parts of it can be changed and maybe should be, including the power to amend the constitution itself. In interpreting and applying the constitution, judges need to avoid stealing the people's birthright, need to be slow to interfere with the people changing the constitution. It's good to inherit a constitution, good to pass it on, improved when need be to posterity. Thank you very much.
Thank you very much, Professor Ekins. Let's open the floor for questions. Let me begin by asking if any students have questions. Yes, right up here. Jonathan, we'll bring a microphone for you so we can capture it on the video too. Go right ahead.
Hi, thank you very much for speaking. So I was wondering, with the court taking like an almost absolutist view on the free speech First Amendment, do you think that that is a way of almost like inheriting the Constitution and then them taking that wider view of it, or is that more them remaking the Constitution then?
So that's a very good question. It's a question that requires me to know more about First Amendment jurisprudence than I may know. But what I suspect is, unfortunately, I think the court probably is over-determining what is otherwise underdetermined, and coming up with some pretty categorical rules for understandable reasons, because it doesn't want from case to case it to look as though the court is sort of putting its finger in the air, and so it's trying to commit itself. And certainly what you inherit in the modern American Constitution, I think, is a pretty absolute commitment to free speech rights. But I think in one sense that's been developed by judicial determination of something that was underdetermined. And so I know there's widespread love, as I understand it, for the First Amendment, but I do have this concern that what are underdetermined rights, open-ended rights, have been made too concrete by the courts in ways I think can be quite destructive. I certainly think of some, as I say, I'm not an expert on First Amendment jurisprudence, but there are certainly some cases that I've seen the court apply an overly categorical rule that prevents the sale of extremely violent video games to children, or the punishment of people who lie about their military record, and things that perfectly reasonable restrictions on lying or on sort of indecency with children. So I think there's a problem with the way the court has proceeded, yes, even if that is part of what you've now inherited.
Interestingly, one of the other two big events going on at the same time here at the university is a discussion of those aspects of free speech. It's going right on, right over there. And you can watch that one on videotape, because it'll be recorded. Other questions? Yes, Ray.
Hi, thanks for your great talk, and I have many, many questions, but I'll just ask one, and then maybe circle back. So
Come
just
back later.
on this last part of your talk on each generation should be able to amend the Constitution and adapt it. And it reminds me also of the beginning of your talk, or authority. I was struck that none of the legal theorists makes the basic Aristotelian argument that law acquires authority the longer it stays in place. And it strikes me that it's embedded in Burke's conception of an inheritance, right? The longer it stands, the more it inspires reverence. And so I'm wondering, and since you also drew this distinction between big C Constitution and small C Constitution, isn't it part of the genius of the American constitutional system that the big C Constitution is so hard to change, thereby ensuring that it stands as it is for so long, with each generation increasingly reviewing it and fearing to change it, which is a good thing, because it then also allows space for the small C Constitution to change and adapt. And isn't, when you consider France, which is on its 5th republic, not to mention other European countries, that it is rather an advantage of the American system that the Constitution, the enacted one, is so inflexible, but at the same time limited so as to leave the small C Constitution, as much room to change and adapt as we've seen just in the last 100 years, much less the last 250.
Thank you. It's a very thoughtful question. And there is something to the idea, certainly, and I didn't speak to it, but I probably should have, that a constitution could certainly be too easy to change. And people could be too minded, too frivolous with their, I suppose it is entailed in much of what I said, actually. You should appreciate what was done for you, and you shouldn't be in a hurry to remake it just because you didn't make it. That would be an odd way to proceed. It's almost what Jefferson invites, I think. You've got to remake it every 19 years because otherwise you're not master of your sort of destiny. I think that's foolishness. And it was part of my claim, certainly, that it's a mistake just to focus on the capital C Constitution. There's a lot of other things going on, and that could be where the engine of change is. I think that's partly true for the American experience, although I think also, unfortunately, Supreme Court doctrine is doing a lot of the work of change. And you end up, I think again, unfortunately, with control of the marginal voting justice being a sort of an existential question for the Republic in a way that certainly one wouldn't have planned it that way, and I don't think the founders had that in mind, and I'm not sure if you had the open choice you would make that your means of principle high constitution making. It would be much better to take open responsibility for the change, even if I'm assuming one can calibrate it such that you get deliberate, thoughtful change, and you're not tearing the thing apart in the way that maybe the French do successively.
Do you want to follow up? Yeah.
Just that it relates to your point about judges. Just how much are we to blame them at the court's authority versus the I think of abortion, of gay marriage, of all these very hot questions that it strikes me that they should have been settled in the Congress.
Sure.
But Congress abandoned the responsibility to the judges, which I'm sure enjoyed taking over some of that responsibility. But it doesn't strike me that the judges or the courts always were so much the driving force of judicial empowerment, as much as just us, the people and the representatives, not wanting to go near these questions and being ever so happy to let the court adjudicate them for them.
Well, no, I think it may vary from case to case. There's a vicious circle going on there for sure, I think, with irresponsibility on one part driving inappropriate taking of responsibility on the other, perhaps. I think, though, there have been plenty of attempts to take responsibility by political institutions that then are disabled and so on. At that point, rationally, you might redirect political attention to where you can make a difference, namely control of the court.
That's all.
Yes. Thank you very much, Richard, for this provoking view. So the idea of inheritance is beautiful and precise because it has an intangible aspect, which is the goods, the fundamental goods that actually we inherit, but also the material historical aspect. But the other thing I thought that I know you know this and omitted, and it's perhaps important to emphasize that the changes that are done through the determinatio, right, of practical reason, rather than from the pure exercise of invention and reinvention in the working style. So that the determinatio, any improvement of the basic goods, is it really improvement or is really a refinement of a good that we inherited anyway? So the point of life is one.
Oh, it's a good point. I think it will vary is the answer, because in some instances it will simply be refinement. In others, it may, new problems do arise sometimes, not maybe wholly new in the nature of things, but we don't always foresee the particular problems under which we'll operate. We may have made provision for them, and so we may have to now make provision for them. And we may have to repair past mistakes as well, of course. I've been praising the inherited constitution, but I think in my discussion, certain aspects of the inheritance may have been, may require excision, actually, because they're unjust or now counterproductive.
Yes, over here.
Thank you for your talk. I share your view that the inherited constitution is positive, but that notion hinges, if I follow you correctly, on one, the ability to change the constitution, the sense by the people that it works towards the common good. But what happens in the case when many people don't believe it's working towards the common good? And you also stated, and I agree, that judicial intervention was not inherited. So how do you resolve this tension between enactments outside the Constitution, one, two, people not believing that it's working towards the common good, and then the difficulty to make that change? How do you resolve that tension? And my main question is, what mechanisms do you propose for that? and would you consider referendums being a valid way of preserving change?
Okay. I think you've nicely described a predicament. It's a predicament I think I'm picking up on too and trying to share. And certainly insofar as a people and a significant number of members of the people are viewing their constitution as no longer a constructive framework for joint government for the common good, that's a very serious problem. And the inability to make changes or even to advance changes with some prospect of success will fuel that sense, I think. So at minimum, making it workable for the Constitution to be changed, such a public conversation about its adequacy and how it might be improved would be helpful to that extent. That's part of that will be recognising there are multiple ways of changing the Constitution in the widest sense. So it could be that the relevant problems can be tackled by changes short of outright constitutional amendment. Maybe the court can temper some or reverse some aspect of its overreaching case law, perhaps, or Congress can enact a new statute like the Administrative Procedures Act or whatever else it may be. As for referendums, I think referendums in general are a pretty terrible way to make law, but the major exception may be in relation to constitutional change, where there can be an advantage in if a question has been posed and developed well by responsible institutions, and the change only being made if it's clear that it enjoys majority support by the electorate that's invited to participate. So it can certainly be a way of grounding popular support and thus social legitimacy of a change. So I think there's a place for the use of referendums as provided it's a technique led by representative institutions in relation to constitutional change. But it's not a panacea.
Richard, some aspects of our Constitution here in the United States virtually invite the Congress to play the role that you just stipulated. I'm thinking particularly of the 13th, 14th, and 15th Amendments, whose concluding sections empower Congress by appropriate legislation to enforce the guarantees of the articles, which would mean that they would have to interpret and fill in the meaning of the guarantees. But when that happens, unlike with the judiciary, it's got democratic legislative credibility behind it.
Very good.
Yeah. Other questions? Yes, Professor Chang.
Thank you so much for a really thought-provoking talk. So I'm going to start with a slight defense of France. Just to say that if we change constitutions so often, it's not out of fun, it's because of historical circumstances.
Sure.
You know,
Okay.
If you think of 1940, it was hard to keep a constitution that basically gave all powers to the Nazi regime. So, and I would, maybe if I want to be very provocative in watching American politics, sometimes I fear that my past is your future, so I would sometimes urge a little bit of caution. But I have two questions of clarification on two points. The first is on consent. If I got it correctly, your emphasis on inheritance, you understand the emphasis on inheritance as a way to avoid the necessity of the consent of the governed, but I don't see how the two concepts are contradictory, because I think inheritance or a deep understanding of inheritance can be a way to secure the consent and the good understanding of the government. So I would be happy to hear clarifications about this. And my second question is on the term you use of birthright, and I think you made a comment in passing about immigration, which I'm not sure I agree with. And here I think the problem is the relation between constitutional law and economics. If you think of the current situation in the United States today, at least as I can understand it, economics cannot work without immigration, even without illegal immigration. And it seems to me to be unfair to say that the people that contribute to the needs of the citizens are not part of the people. So this goes back to the question, the very interesting question you raised about what makes a people. So
Sure.
I'd be happy to hear your thoughts about this.
Thank you. Well, to the extent I impugn the honour of France and its successive constitutions, I withdraw the remark. But so excellent questions. I think you were right to think that consent and inheritance are not sort of alternatives, and I didn't mean to frame them as such. Really, I attempted, I think, in company with Finis and Raz, for what it's worth, to clear the ground for consent as a foundation for authority. And instead and this is, in a way, trying to build up the picture of the principle of continuity and the common good as a foundation for government. Now, securing consent is a jolly good idea. It helps make all aspects of government more straightforward. But I think it's wrong to think of the people as enjoying a capacity to simply to sort of cancel their government or radically remake it in a way that can risk all manner of evils. So in a sense, my discussion of inheritance came later in a way and was designed to show that the reasonable disposition that a people has towards its past. And not to think of themselves, I think the people should consent to government, but they shouldn't think my consent is what makes this authoritative. So that's a distinction I'm attempting to observe. In relation to the point about birthright, I'm a naturalised citizen of the United Kingdom, and I think I've been adopted into the people with consent, and I'm glad of it. And it's certainly no part of my argument that immigrants can't join a people, and obviously this country has astonishing success at integrating successive generations of immigrants. There may be some limitations to how far that can be undertaken, but the limits go quite far. I think there's a major difference between illegal immigration and legal migration in this context, though. And I don't know how far your point was that the economy of the United States depends on illegal migration, which it may well do. At which point there may be a tragic state of affairs in one way, that there are some reasons to be concerned about breach of migration law and the effects on the character of the people if the people are now being constituted in part by ones who have entered in breach of migration law, and yet it may be an economic necessity in some way. And obviously any particular migrant who's entered in breach may be more or less understandable, and there may be a case for argument about the nature of enforcement and so on. But I think I hold on to the point actually that there's a real significance to the determination of who forms the people, and to the extent that illegal migration is a major feature of this country's experience and my own and others, that is a major problem for forming and maintaining a people. Not an insoluble one, maybe, especially if the children of illegal migrants perhaps have a different experience, but it is a problem.
Yes, right next to you, Christy. Yeah, there you go, sir.
Hi, thanks very much for your talk. I thoroughly enjoyed it. Just want to go back to your comments about the Bill of Rights to make sure I understood you correctly. Is it your argument then that maybe the Bill of Rights in retrospect created a bit of a platform for something in the way of judicial mischief, making things a little bit too malleable and open? I mean, it was kind of an exercise of the anti-federalists. Hamilton's comment was, the Constitution is a Bill of Rights. We don't need a Bill of Rights. So I just want to dangle it out there and say that, in retrospect, has it created avenues that maybe should not have been opened?
Well, that was exactly my point, really. And it may be that it was unavoidable under circumstance. It had to be adopted as a political compromise, in which case, well, fair enough. But it does seem to me to create major risks, and some of those risks have been realised. I mean, there's recent scholarship, but probably it's old scholarship too, making the point that I made about how the Bill of Rights may be conceived as underdetermined rights, the principal enforcement of which will be Congress and state legislatures, in which case that would be a much more attractive state of affairs. But I think it was a risky enterprise to adopt those amendments, and I think the risks have partly manifested.
Yeah, I know that my students who are here know this, but it might have come as a surprise what the gentleman just said to some others in the audience. Yes, Hamilton opposed the adopting of a Bill of Rights. That's why the Bill of Rights appears not as part of the original unamended Constitution, but rather as a set of amendments. Next question. We'll go over here. Zach Gordon.
Thank you so much for the talk. And going off of your skepticism of the Bill of Rights, one thing that's always in my studies of the English Constitution and the American Constitution that has always really surprised me is how deft the English Constitution was able to continue to renew itself, to re-justify itself, that it was always casting itself, to your point, into the past, into this immemorial sense of inheritance in a way that sometimes our Constitution proves very difficult to do since it is a text, since it is written. And so I'm curious if you could speak a bit to American citizenship and Americanness as being a very hermeneutic identity or activity uniquely to us, that it seems to be that we're so kind of rooted in these texts that we love that we can often, to your point, prove mischievous with our own interpretive abilities. So what does it mean to have an interpretable constitution versus one that's more just inherently inheritable rather than something that is on the page that we can read in our own language 200 years later?
Okay, it's a very interesting, thoughtful question. Clearly, the early Americans are closely related to the British and so are sharing many of the same texts and political practices with some important differences. They face a different predicament and so have to innovate to some extent and are undertaking an artificial process which is deliberate making of a new compact. And there have been compacts in the English past, but they're not of that constitutive nature. They're more limited and ad hoc, if you like. We haven't faced the same need, in a sense. And so that makes the American founding strikingly different, perhaps, and then makes it have a kind of gravitational force, I suppose, for obvious reasons. It's there and it forms a major part of identity in a way that no equivalent constitutional moment in British history does. The Glorious Revolution is really important and so various other aspects and so on, but they don't have that people constituting character to them, and we don't go back to them in the same way. I teach my students about them, but and some people know about them, but it doesn't kind of live in that same way. So what's inherited is more of an ongoing political practice. So that's probably unavoidable in one way for Americans, especially given how the extreme expansion of the country and incorporation of new peoples who then are formed partly around this. I think it might be helpful, though, to recognise, maybe you do, and if so, I apologise, but to recognise the extent to which the wider Constitution matters as well. So that important though the capital C Constitution is, it's not the only show in town, and that the other aspects of the Constitution are really very important too and shouldn't be overlooked. And do form part of the way you're governed. And they warrant repair and change and addition, and that's a way of dealing with some of the difficulties that might arise from the capital C Constitution, even if not a way of substituting it entirely.
Richard, Zach there is one of our university's nominees for Berry Scholarship, which, as you know, is the Rhodes
Very good.
Scholarship, only better. So if there's justice in the world, it will be yours.
See you in Oxford next year. Very nice. Okay.
Yeah,
That's
we
exciting.
have a question all the way in the back.
So thanks. I'm broadly very sympathetic. I do view the Constitution as an inheritance to be grateful for. But I'm curious to what extent you think your argument is dependent on some contingent features of today. So if you were to think about different points in time, which you sort of acknowledged the Constitution was
Sure.
not made for, say, lots of classes of people, slaves, women, etc. Whether at those times when the even small c Constitution had not been extended to those people, whether viewing it as an inheritance to be grateful for would be a good attitude, both in two senses. One, it's kind of hard to see how Frederick Douglass could view the small c Constitution, at least, as something he should feel grateful for. But also, if you think of it as an inheritance, does it not make it easier for the people who do enjoy the blessings of the good that's been achieved to go, this group of people is trying to steal my inheritance, which does appear to be sometimes the way that line of thought goes, which is, these slaves are trying to take what, our fathers gave to us and not to them. So yeah, to what extent is this attitude contingent on the fact that now at least the small and big C Constitution do sort of, I think, by and large, grant these goods to all members of the community?
So, great question. And yes, I mean, I referred to the significance of it being a broadly worthy constitution, and at different points in time, you might make a different judgment about that. Now, you referred to Frederick Douglass, and I, in preparation for this, and you will have done this years ago in school maybe, but I read his "What does the 4th of July mean to a slave?" and is the Constitution a pro-slavery document. I think actually he was grateful for the Constitution, actually.
The capital C,
yeah.
I think his point is it's the small.
Oh, I see, okay. Oh, well, I mean, he certainly wasn't grateful for the abomination that was the institution of slavery. It's an extraordinary railing against it. And clearly the Constitution didn't stop. In fact, it partly made provision for, at least in the early stage, the continuation of the institution, at least in some minimal sense. So, yeah, there's certainly a question there. Is this something you should be grateful for? I think the answer probably is still yes, because it's providing a framework for government that is securing a whole host of goods, and that also provides a framework for self-conscious and deliberate addressing of this injustice. So it wasn't as though this was, it would have been a different matter, I think, if the Constitution had been, which he said it wasn't, formally committed to the injustice of slavery, and thus had ruled out action to take, but actually provided a framework to talk about it, to address it, and that is something too to be grateful for. Now, on the second point, I mean, I think it would be, I'm sure it could have happened, and almost certainly it did, given the perversity of human affairs, for slave-owning Americans to think that somehow their birthright was being stolen by sharing the inheritance of the Constitution with enfranchised slaves. I think that's wrong as a moral matter there, clearly, and I don't think the idea of inheritance of the Constitution is sort of committed to indulging that. Maybe it doesn't tackle it adequately. There's always a question, who is the people? Who should the people be? It kind of makes sense in the early American founding that the Indian tribes are not part of the people because they're living separately and they don't think they're part of the American people. The position of the slaves is clearly very different because they're living day by day but under repression. So I think, yes, you could leverage the idea of inheritance there to exclude those with whom you really should be sharing a political community. And the idea of inheritance is not going to solve that problem. What you need to solve that problem is a proper argument about who's entitled to be part of the people and on what terms you can treat people.
Closing question, Mike Rossen, was your hand up there?
Yeah.
Yeah, there you go, Mike. Oh, wait for the microphone. There you go.
Perhaps we should distinguish between the inherited and the inherited star constitution. The inherited star constitution has inertia but can be amended. Article 5 is very clear that the people didn't have the power to amend the Constitution, to give themselves the power to stop the importation of slavery for 20 years and equal suffrage. The great second founding was with the Reconstruction Amendments. In December of 1860, Stephen Douglas proposed an amendment that would have denied states the power to give the vote to their citizens of color or to allow them to hold office. As bad as that was, it was also unamendable. Unfortunately, it went,
Sure.
the cataclysm happened. Do you think an amendment like that or any other can be so entrenched? And if it does, if it puts itself beyond amendment, does it lose legitimacy? And is it not worthy of being considered part of the inheritance? If anybody should have tried to have done that or do it now.
Oh, I think it falls squarely into the category I had in mind when I said inheritance shouldn't be a trap or a snare. And that very much would be. And it would be the act of hubris that I suggested at the start. No one should be attempting to insulate the Constitution from deliberation and change later on, especially not when it's not a structural provision like there being a federation, but is a commitment to a particularly perverse policy choice of how you treat other people. So by all means, if that had succeeded, then you would have placed an enormous question mark or an asterisk next to the legitimacy of the Constitution, because you'd have to break it, I think. You couldn't live with that. How you would break it...
I still can't figure out whether you can really put an unamendable provision into a constitutional amendment.
I think you could, as a matter of the system that is the logical system. But what you would have done then, I think, would have been to make the thing, for good reason, much more brittle, because then the only way out would be to smash it. I mean, maybe in the most orderly way possible to minimise disruption, but...
Well, it does my heart good to think of how pleased my great friend and predecessor, Walter Murphy, would be not only with the wonderful lecture that Richard gave us, but with the superb discussion.
Absolutely.
And I thank everyone for those excellent questions. I know, Richard, that you're grateful for them as well.
Certainly.
So please join me in thanking Richard Ekins.